Franks.
Thank you, Mr President. I move that the bill now be read a second time. Indeed, Mr President, it is not the first time that the issue of medicinal cannabis and driving while a legally prescribed medicinal cannabis patient has been raised in this place, and I do indeed credit the work in the previous government of the Honourable Kelly Vincent before I go much further. But I also note that this bill, which is based on a fair, a just and effective system for drug driving laws for medicinal cannabis patients, is very much based on the work of Drive Change and their wonderful leadership on this issue indeed must go recognised. Medicinal cannabis patients generally reduce the use of other impairing prescription drugs like opioids and benzodiazepine, and indeed in states of the United States where legal medicinal cannabis is present, they have seen no increase in road toll statistics. Indeed, there's no evidence that in the Australian road toll that there's been any impact as a result of the mouth swabs for cannabis in indeed making our roads safer. However, patients who seek legally available prescription medication, if it is cannabis, are denied the ability to have a medical defence when it comes to drug driving charges and drug driving detection. Indeed, Germany provides such a defence if the driver is not impaired. Ireland provides such a defence if the driver is not impaired. New Zealand, Norway, the United Kingdom all provide such a defence if the driver is not impaired. However, in mainland Australia, because with the exception of Tasmania, that it does indeed already cover this ground, in mainland Australia such a defence is not available. The average medicinal cannabis patient in Australia is a 49-year-old. This is not somebody who is undertaking this lightly, and indeed the most likely reason they are taking the medication is for pain, anxiety or multiple sclerosis. Indeed, of the 60% of the legal products that are available are oil-based, which means that the THC within them, should there be THC within them, is metabolised at a very slow rate. Yet of some 35,000 active legal medicinal cannabis patients in our nation, some 70% of whom are taking a medication with THC in it in some form, they are not able to legally drive in mainland Australia, should they fall foul of our drug driving detection systems. And our drug driving detection systems are more profound and present than ever. Indeed, in the last few years, the approximate number of a roadside drug test in South Australia that was undertaken annually was some 49,000 or so. And of those tests, the saliva or mouth swab test would detect an amount of THC in that person's saliva for some 24 to 72 hours after the cannabis had been taken. Should it be a blood test, it can detect it for 6 days after the cannabis was taken. A urine test is actually an entire month after it was taken, and a hair follicle test may indeed detect it for some 3 months. And yet, the peak period at which somebody might be impaired, if they are to be impaired by this medication, would be some 2 to 3 hours after taking the medication. So tests that find it 3 days, almost a week, a month to 3 months after it has been taken clearly are not testing for impairment, they are testing for presence. And presence does not mean impairment, Mr President. Yet that very presence at a first offence could see somebody facing a fine of over $1,000 or disqualification of their licence, and indeed, should they face not go to court, the expiation fees starting at $803 and upwards. These are quite serious penalties. A second or third offence sees further punitive actions be able to taken against a patient who is simply seeking a medication, as I noted, for the most likely common cause being pain, anxiety, MS. Indeed, medicinal cannabis is prescribed for a range of reasons, including disordered eating. As many members are aware, it has now been legal in Australia since 2017, and our prescribing system is developing, but indeed GPs are successfully prescribing medicinal cannabis for a range of reasons in our state, and yet often those patients find themselves, say, with chronic pain or fibromyalgia, unable to take the very medication that they know will help them. In fact, that they often know will help them to function more safely in our society with less chronic pain, but they know that they will fall foul of our drug detection laws should they take the medication, and not just for 2 to 3 hours after taking that medication, but indeed for days and weeks after taking that medication. So in effect, this makes it impossible for a patient to risk losing their licence, to risk losing their access often to work or indeed to the usual leisure activities that are enjoyed by all in South Australia, should they actually then find themselves the subject of a roadside drug test, or indeed should they find themselves in an accident and subject to the various other testing regimes that would take place then. We heard today in this parliament, in the balcony room, from Adjunct Professor David Hilpern. He's been a magistrate for some 21 years, but he is a magistrate no longer, Mr President, because last year he actually quit over this very issue, and he is now the lead agent in the campaign to drive change. Former Magistrate Hilpern actually was joined at that round table by a local doctor, an Adelaide GP and member of the Australian chapter of Cannabis Clinicians and the Australian Medicinal Cannabis Association, Dr Joel Wren, acting in his own individual capacity, but he gave us evidence of the difficult situation patients are put in, having to choose between taking the medication that they know will help them or indeed being able to not fall foul of these particular laws that are not present in other countries, are only present in Australia and only detect presence, not impairment. They are in some ways nonsensical laws due to that, and indeed they have been identified as laws worthy of this bill before us today by no lesser than the Australian Lawyers Alliance. And I draw members' attention to their press release dated today, which reads that current drug driving laws are not fair to drivers who can lose their licences for taking prescribed cannabis when there is no evidence of impaired driving. Indeed, to quote Sarah Vanal, the South Australian State President of the Australian Lawyers Alliance, current drug driving laws in South Australia are simply not fair. People lose their licences and sometimes their job, not because of impaired driving, but because of flawed laws. They go on to say, we support the bill introduced today because it will fix this unfair and outdated law that severely penalises medicinal cannabis patients. Drivers who take opioids or other prescription medication do not find themselves in court or risk losing their licence, and neither should drivers who have taken a prescribed and legal dose of cannabis. These drug driving laws were developed before cannabis became a legally recognised prescription medication, and the law needs to change to stay relevant. Currently, it is illegal to drive with any presence of THC detected, regardless of whether a person is impaired. This makes cannabis the only prescription medication that excludes an individual from driving completely. We urge all legislators in South Australia and the South Australian Government to support this bill. And indeed, this bill is replicating a bill in Victoria that has received the support of the government there. The Honourable Fiona Patten, MLC in Victoria, has introduced last year an almost identical bill, and there, in cooperation with the Andrews government, has referred that off to a task force which has late last year reported back to the Parliament and continues to meet. Indeed, a great body of work has been done there in Victoria with the police and with other stakeholders to try and find a model that will ensure that medicinal cannabis patients can safely take the prescription medication their doctor believes is suitable for them, but not find themselves further criminalised by drug driving laws that have not kept pace with the legalisation of medicinal cannabis. Indeed, it is cited as a major barrier to patient access, and that was identified during the recent Senate inquiry. And indeed, that Senate inquiry identified the reform of driving laws as one of the key recommendations of that Community Affairs References Committee. That was certainly backed by many involved in the inquiry, and most notably the Lambert Initiative, who recommended options for law reform here. But again, I'll leave the final words today to then Magistrate Hilpin, who stated, "Throughout the thousands of cases I dealt with, the police were never able to allege that any person was showing any signs of affectation. They weren't wobbling as they walked, they weren't slurring their words, they didn't have bloodshot eyes. Most, if not all, the people who were prosecuted in New South Wales have a level of THC in their body that bore no connection to their ability to drive safely. Unfortunately, these laws should be completely abolished. Ultimately, these laws should be completely abolished. There is simply no justice in these laws and the way they're applied, particularly for those who are using cannabis medicinally. They're a waste of money, they're a waste of police time, and they aren't achieving any of their aims. And it's high time we got rid of them." The then magistrate is quoted as saying, and I couldn't agree more, Mr President. And with that, I commend